Good day, class, and welcome to Chapter 2 on partnership. We're now going to take Section 2, Property Rights of a Partner. So let's begin. So Article 1810 of the Civil Code, the property rights of a partner are, number one, his rights in specific partnership property. Number two, his interest in the partnership. And number three, his right to participate in the management. So let's tackle this one by one. But first, let's discuss the difference between partnership property and partnership capital. Partnership property, the value is variable daily, whereas partnership capital, the value is constant. It is the amount fixed by agreement of the partners. So class yung partnership property, so this changes every day, no? It depends on, let's say may pumasok na cash or property sa partnership within a day, then that is partnership property. So depending on the number of transactions a partnership business has, nagbabago yung partnership property niya. Whereas yung partnership capital, it is what's agreed upon by the partners. It's what they have contributed. Dumadagdag lang yan kung may pumapasok na net income na towards the end of the year. Alright? The partnership property, it includes not only the original capital contribution of the partners, but all property subsequently acquired with partnership funds. So lagi nagbabago tong partnership property, Ang partnership capital, it represents the aggregate of the individual contributions made by the partners. So this really focuses on the contributions of the partners and nothing else. All right? So mas fixed yung partnership capital kasi ito yung magiging basis kung paano yung hatian ng mga partners when it comes to profits, etc. So ownership of a certain property, number one, the property used by the partnership but still owned by the partner. So a partner may contribute to the partnership only the use or enjoyment of the property. The intent of the parties is the controlling factor. So class, pwede naman, no? Pwede naman na, let's say, ako gusto ko mag-contribute sa partnership, pero yung ownership na kino-contribute ko, for example, kotse, o kaya lupa, no? Pwede naman na ako pa rin ang may-ari nung lupa na yan or kotse. Pero yung paggamit, kino-contribute ko sa partnership yon. Pwede naman yon, right? Property acquired by the partner in his own name using partnership funds, this is presumed to be partnership property. So pera daw ng partnership yung ginamit. No? So kahit sa pangalan ng partner ilagay, sa partnership pa rin yun. Alright? Sa partnership pa rin yung property na yun. That is the presumption. Number three, property carried in partnership books as partnership asset. There is a strong inference that it is partnership property. So nasa books of accounts, no, na asset siya ng partnership, then malakas na ebidensya that it is a partnership property. Number four, other factors tending to indicate property ownership. When income generated by the partner is received by the partnership or when the taxes on the property are paid by the partnership, they are also evidence that the property is partnership property. So what is the nature of a partner's right in specific partnership property? Number one, there is equal right of possession of the property for partnership purposes. Importante class yung for partnership purposes, no? A partner has an equal right to possess specific partnership property for partnership purposes. No partner can possess and use partnership property other than for partnership purposes. However, the right to use specific partnership property may be surrendered upon the partner's agreement to the managing partner, especially with a partnership with a large membership. So class, no? So when it comes to the partnership property, pwede to gamitin ng kahit sinong partner, but only for partnership purposes. Assuming na walang inassign na na managing partner. So every partner class is actually a managing partner. All right? So kahit sino dyan, pwede gamitin ng partnership property but only for partnership purposes. For example, ang partnership business nyo ay nagpaparenta kayo ng ng kotse, no? Na may ano na ang mga partners sila din yung driver, kunwari, no? So kahit sino sa mga partners na yan, pwede ilabas yung kotse para mag-drive ng customer. Alright? Pwede ba yung partner na gamitin yung kotse para mag-enjoy siya, para mag-joyride ng siya lang? Hindi pwede yun. That is already outside the partnership scope, no, or purposes. All right, class. So assignment of right to the property. A partner cannot assign his right to the land, but all of them can assign their rights in the same property altogether. No? So a partner cannot mortgage or assign his interest in the specific in the partnership property because it is actually impossible to determine the extent of his beneficial interest in the property until after the liquidation of partnership affairs. And this is also to protect the other partners, to prevent interference by outsiders. A retiring partner can assign his rights and partnership property to the other partners, continuing the business. So class, so let's say may partnership tayo. Alright, ang assets natin, meron tayong lupa, meron tayong building, meron tayong iba-ibang equipment. Alright? Let's say ako class, no? Let's say partner ako sa partnership natin. Tapos gusto ko ng pera, no? So ang ginawa ko, pwede ba na gawin ko na let's say kumuha ako ng gamit from the partnership tapos inassign ko yung right na yon or binenta ko sa ibang tao? The answer is no. Right? Bawal yon. I cannot assign any right to a partnership property. Right? Because that property belongs to the partnership which has a distinct and separate personality from the partners. Alright, class? So kapag lupa ang pinag-uusapan, no, hindi pwedeng i-gawing collateral yan. Hindi yan pwedeng i-mortgage ng partner kung gusto niya umutang because that is partnership property. Kahit sabihin niya, teka, dalawa lang naman kaming partners. So ang imo-mortgage ko yung kalahati lang ng lupa. Pwede ba yun? The answer is no. Bawal pa rin yun. Alright? The law is very clear. A partner cannot assign his right to the partnership property, but all of them can assign their rights in the same property altogether. Ibang usapan, class, kapag, let's say, dalawa lang ang tao sa partnership. No? Kapag isang partner lang yung nag-mortgage ng property, kahit kalahati lang, bawal yon. Paano kapag yung lahat ng partners o yung dalawang partner in this case, in case dalawa lang yung partners sa partnership, pwede nila i-mortgage yung partnership property. Alright? Pwede lang i-mortgage yung partnership property kapag lahat ng partners ay papayag doon. Okay? Hindi pwedeng yung iba lang, hindi pwedeng yung isa lang, dapat lahat para ma-assign yung partnership property. Otherwise, hindi pwede gawin yon ng kahit sinong partner. Attachment or execution. Partnership property is not considered a separate or individual property of a partner. It belongs to the partnership as a juridical person, like what we stated in the previous slide. Partnership property is not subject to attachment or execution, except on a claim against the partnership. So, let's talk first about attachment or execution. For example, dalawa tayong partners. Tapos ako, marami akong utang. Unang-una muna, class, ano bang ginagawa nyo sa taong marami ang utang? For example, kinukulong ba? Hindi kinukulong ang taong may utang na hindi makapagbayad. Unless there is estafa, but that's a different story. Alright? Pero there can be no imprisonment for non-payment of a debt. Okay? So if you are a creditor, class, tapos meron kang debtor na ayaw ka bayaran, no? And let's say estafa is out of the picture. Estafa, class, is a criminal case, by the way, no? Hindi mo kasi porke hindi makapagbayad, estafa na kagad. Because in estafa, there has to be the element of fraud. Alright? And fraud is actually hard to prove. Pero yung ito ano, let's say wala namang fraud pero basta ayaw lang magbayad. So anong pwede mong gawin sa taong 'yon? Alright? Kakasuhan mo, yes. But after mo kasuhan tapos hindi pa rin makapagbayad, anong gagawin? No? Pwede mong i-attach yung mga properties niya. Tapos ano mangyayari? Sa'yo na lang ba yun? Hindi. Ang gagawin, pag in-attach mo yung properties niya, for public auction yan. Ibebenta yung mga properties niya, tapos kung ano man yung mapagbentahan noon, i-apply yon sa utang sa utang sa'yo. No? Is that clear, class? So ngayon, balik tayo sa partnership. Let's say ako, partner ako, maganda yung partnership ko. Maganda yung partnership namin. Pero ako bilang partner, marami akong utang. Hindi utang ng partnership, utang ko as an individual. Naubos na yung in-attach ng mga creditors ko, yung lahat ng mga personal assets ko, ubos na. Kaya ang natitira na lang, yung partnership property. Kasi nakikita na rin yung partnership properties, masyadong mahal, masyadong maganda. Ngayon, gusto nila kunin yung partnership properties. Pwede ba nila kunin yung partnership properties? The answer is no. Alright? Because ang sabi dito, partnership property is not subject to attachment or execution except on a claim against the partnership. Anong sabihin yan? Kung ang may utang, class, ay yung partnership. Alright? Kung ang may utang ay yung partnership, tapos hindi makapagbayad yung partnership, pwedeng i-attach yung mga partnership properties. Alright? So class, by now, dapat alam nyo yung sabihin ng attachment. No? So you also learn that in your oblique 1. Alright? Ang attachment, gaya na sabi natin kanina, ito yung pag-attach ng mga properties ng debtor, no? Para ibenta to sa public auction, para yung proceeds nun, yun ang ipambabayad sa utang. And that is attachment. Okay? And so kapag separate liability, kapag separate creditors ng partner, no, hindi nila pwedeng i-attach yung partnership property. So that should be clear. No? When it comes to partnership debts, no partner can claim any right under the homestead or exemption laws when partnership property is attached for partnership debts. Anong sabihin ito, class? For example, ito, partnership property. Pero nagkataon, parang bahay din siya ng isang partner. Pwede mangyari yung, class, no? Ngayon naman, class, let's say may utang yung partnership. Hindi siya makapagbayad. So yung partnership property, i-attach ng mga creditors. Alright? Hindi pwedeng umalma yung partner na doon nakatira sa partnership property. Alright? Kasi class ganito, if you are a debtor, tapos may utang ka, no? Tapos ina-attach yung property mo, hindi pwedeng i-attach yung family home mo. Alright? Up to the extent of only 300,000 pesos actually. If it's more than that, yung excess pwedeng i-attach. So class, that's clear, no? Kung may utang kayo, tapos di kayo makapagbayad, hindi pwedeng i-attach ang family home. But there's only an extent up to what amount? No? It's 300,000 pesos as far as I'm concerned. All right. However, a partner's interest in the partnership itself may be levied upon by a judgment creditor because it is actually his property. Anong sabihin nito, class, no? So nalaman natin, napag-aralan na natin na hindi pwedeng i-attach ang partnership property para sa separate na utang ng partner. Ano lang pwede i-attach ng creditor, class? Ano lang ang pwede i-attach ng separate creditor ng partner? Pwede i-attach yung interest ng partner doon sa partnership. Ulitin natin, ha. Pwede lang ma-attach yung partner's interest in the partnership. Ano ba yung interest na yan? Ano ba yung interest na yan na sinasabi? We will be discussing that in the next slide. Pero sa ngayon, ibig sabihin yan yung share ng partner doon sa partnership profits at sa yung sa share niya na matitira kapag nag-liquidation. Alright? And legal support. A partnership property is not subject to legal support under the family code because the property belongs to the partnership. However, a partner's interest in the partnership itself may be subject to legal support because it is actually his property. Parang kanina, yung partnership interest. But before that, class, napag-usapan natin yung legal support. Ikaw, no? So, who is entitled to legal support, class? It's the, ano, no? It's the married spouse. Ano pa? It's the children, actually. Right? It's the children that require legal support. Okay? So, let's say, to kunwari class, no? Let's say you have an illegitimate, you have a child na lang. Let's say you have a child. Alright? Tapos, hindi ka nagbibigay ng suporta dun sa child mo. Okay? Tapos, kinasuhan ka ng petition for support. Eh, nasabi ng court, o teka, may partnership pa pala. Yung partnership property mo na lang, yung gamitin sa pag-support para dun sa anak mo. Pwede ba yun, class? Hindi pwede yun. Okay? Because partnership property belongs to the partnership. It does not belong to you. Alright? Ang pwede lang masubject sa legal support, yung interest ng partner sa partnership and yung share ng profits, etc. Partner's interest is not a debt due from the partnership. A partner is not a creditor of the partnership for the amount of his share. His interest in the partnership is not a debt of the partnership to him. So a partner's creditors cannot go after partnership property. They can only go after the interest of the partner in the partnership. However, the creditors do not become partners of the partnership. So class, sinasabi lang dito, yung interest ng partner sa partnership, hindi yung utang ng partnership dun sa partner. Alright? Hindi siya utang in a strict legal sense, no? Article 1812, a partner's interest in the partnership is his share of the profits in surplus. So let's talk more about this. So a share of the profits in surplus, it consists of the partner's proportionate share in the profits during the life of the partnership as a going concern and its share in the surplus upon after its dissolution. The interest is assignable by the partner in the absence of any agreement to the contrary. It is considered personal property. So ano bang sabihin ng profit? It means the net income of the partnership over a time period. Surplus means the excess of assets over liabilities, but this is only after liquidation na, no? So yung profits class, no? So ito yung share ng partner sa profits, no? Yung itong interest na to, itong partner's interest in the partnership, which is the share of the profits, it is assignable. Pwede mong i-assign yan. O pwede yung kunin ng creditors ng mga ng partners. Alright? But yung creditors na yon or yung assignees ng interest ng partner's interest, hindi sila nagiging partner sa partnership. Alright? So talaga may directus personae pa rin na element sa partnership. Para maging partner yung assignee, dapat pumayag muna lahat ng ibang partners. Extent of the partner's interest. The partner's interest is his proportionate share of the balance after paying all the debts and receiving all the credits of the partnership. The interest is available for the satisfaction of the separate debts of the partners. As we have discussed earlier, no? The value cannot be accurately determined until liquidation of the business. Because class, like we said, no, ang partnership property, nagbabago yan. Yung value ng partnership property, it changes every day, no? Depende sa cash na pumasok, no, sa income na pumasok. So, malalaman mo lang talaga yung extent ng partner's interest sa surplus upon the liquidation of the partnership. So what is the effect of assignment of partners' whole interest in the partnership? So mere assignment of a partner's interest does not dissolve the partnership. So tuloy-tuloy pa rin yung partnership. Kahit yung isang partner o yung ibang partners, inassign nila yung interest nila. So parang walang pakialam doon yung partnership, no? The assignee has no right to interfere in the management, no right to require any information or account, and no right to inspect any of the partnership books. So in short class, hindi pwedeng mangialam yung assignee or yung creditor ng ng partner na pinag-assignan niya ng interest. Okay? The assignment does not divest the assigner of his status and rights as a partner. Ang partner pa rin kasi, edi yung assigner o kaya yung debtor, yung partner na may utang. And no one can become a partner without the consent of the other partners. What are the rights of assignee of the partner's interest? Number one, to receive the profits accruing to the assigning partner in accordance with their contract. Number two, to avail himself or herself of the usual remedies in the event of fraud in the management. Number three, to receive the assigner's interest in case of dissolution. Number four, to require an account of partnership affairs only in case the partnership is dissolved. So class, this is important, no? Because kapag hindi naman dissolved yung partnership, hindi pwedeng mangialam yung assignee ng partner's interest. Okay? Pwede na siya magtanong-tanong, pwede siya humingi ng inquiry doon sa partnership affairs kapag dissolved na yung partnership. Right? Para malaman niya, no? Para malaman niya yung kung tama nga yung interest na mapupunta sa kanya, na mabibigay sa kanya. But only after the partnership is dissolved. Kapag ongoing pa rin yung partnership, hindi pwedeng mangialam yung assignee ng partnership interest. Hindi pwedeng mangialam yung assignee ng partner's interest. So what are the remedies of a separate judgment creditor of a partner? Number one, its application for a charging order after securing judgment on his credit. A separate creditor cannot attach or levy upon specific partnership property for the satisfaction of this credit. However, he can apply to the court for a charging order subjecting the interest of the debtor partner in the partnership with the payment of the debtor partner's debt. So class, nalaman natin kanina, no? Na pag yung partner may utang sa ibang tao, hindi utang ng partnership utang lang ng partner in his own capacity. Utang niya sa ibang tao. Ngayon, ubos yung separate assets niya. At ang natitira lang sa kanya ay yung interest niya sa partnership. So nalaman natin kanina na hindi pwedeng i-attach yung partnership property. Tama ba? So yung bawal i-attach yun. So ano ngayon ang remedy ng creditor ng partner? Mag-a-apply siya ng charging order. Saan i-apply yung charging order? I-apply niya yung charging order doon sa interest ng partner sa partnership para makuha yung share sa profits, etc. etc. Kasi yung share sa profits, hindi na sa partner mapupunta. Mapupunta na yon sa creditor ng partner. But this yung number 2 class, no, this is a very important rule. Preferred rights of partnership creditors. The partnership's creditors are preferred. Claims of partnership creditors must be satisfied first before the separate creditors of the partners can be paid out of the interest charged. So class, no, paano kung yung partnership mismo may utang din sa ibang tao? So class, pag ganun, uunahin mo yun. Uunahin mo yung mga creditors ng partnership. Alright? Unahin mo yung mga creditors ng partnership before the separate creditors of the partners themselves. Okay? Hindi pwedeng mauna yung separate creditors ng partners kaysa doon sa partnership creditors. So unahin palagi yung partnership creditors, yung mga nagpautang sa partnership. So availability of other remedies. The court may appoint a receiver of the share of the debtor partner's share of the profits. So ito class, no? So yung court mag-appoint ng receiver, yung tagatanggap ng share ng debtor partner dun sa profits. This is assuming na hindi sila magkasundo. So pipilitin sila ng court, no? Mag-appoint yung court ng receiver. So redemption or purchase of interest charge. The interest of the debtor partner that has been charged may be redeemed with the separate property of any one of the partners, or may be redeemed with the partnership property with the consent of all the other partners whose interests are not charged. Ano bang ibig sabihin nito, class? Alright? So let's say merong creditor yung partner. So ang ginawa niya, nag-apply siya ng charging order. So siya ngayon na may hawak ng partner's interest. Anong pwede gawin ng ibang partners doon, class? Meron silang option, no? Merong option yung ibang partners, class. And sa pilitan to, ha. Pwede nila kunin, no? Pwede nila i-redeem. Na nakasulat dito, redeem. Ano ibig sabihin ng redeem, class, in ordinary parlance? Ibig sabihin ng redeem parang save, di ba? So, yung mga partners, assuming na isa lang, kunwari, no? Yung isa sa mga partners or kung ibang partners, pwede nila i-redeem yung interest na yon using their separate property. Alright? O di kaya, pwede siya i-redeem using partnership property. Assuming there is consent of all the other partners whose interests are not charged. Right? So dalawa yung scenario ng possible redemption. Number one is yung ibang mga partners, they can use their separate property para ma-redeem yung partner's interest. Alright? Isa pang option, yung partnership mismo ang magre-redeem. Assuming there is consent of all the other partners na hindi na charge ng interest. na hindi charge ng interest nila sa partnership. Alright? Bakit ganito, class, no? Bakit may ganitong option yung mga partners o kaya yung partnership na i-redeem yung partner's interest? Because, class, kasi ayaw naman ng partners, ayaw din ng partnership na parang hindi naman nangingialaman, no? Pero parang there's a third person na nangongolekta ng profits nila. Alright? Kaya binigyan sila ng remedy ng batas to redeem kung gusto nila. Alright? So, class, importante itong redemption of purchase of interest, no? So we go now to section 3, which is obligations of the partners with regard to third persons. So this is very important, class. This is where estoppel is involved. No? So class, the word estoppel, lagi itong ginagamit sa batas. This is always used in the law. This is always used when it comes to court proceedings. Importante yung word na estoppel para sa mga abogado. Importante rin to para sa mga law students at sa mga accounting students who will be taking the board exams. So let's talk first about the importance of having a firm name. This is to distinguish the partnership, which has a distinct and separate juridical personality from the individuals comprising the partnership and from other partnerships. It must be registered with the DTI. What is DTI, class, no? So Department of Trade and Industry. Okay. However, non-registration will not affect the validity of the partnership. Ano, class, kung may partnership ka, tapos hindi ka naman nagre-register sa DTI, meron pa rin bang partnership? The answer is yes. Alright? So may partnership pa rin kahit wala kang mga rehistro, kahit wala kang mga papers, etc. May partnership pa rin. Pero syempre kapag hindi ka nagrehistro, kapag wala kang papeles, exposed ka sa BIR, no? Exposed ka rin sa BPLO. Pwede mo pasarado yung business mo if you're earning so much, no? Tapos wala kang binabayad na taxes, wala kang registration, etc. Liability for contractual obligations of the partnership. So ito, partnership liability, number one. Partners, including industrial partners, shall be liable pro rata with all their separate property after all the partnership assets have been exhausted for the contracts entered into in the name and account of the partnership. The liabilities are pro rata and subsidiary. So class, pay attention to the wording, no? The wording here is for the contracts entered into in the name and account of the partnership. So kumbaga dito, there is a legitimate transaction of the partnership. Alright? Tapos, hindi nagampanan ng partnership for whatever reason. Alright? So para ma-fulfill yung obligation ng partnership, paano kapag ubos na yung assets ng partnership? Ang maging liability dito ng partners is pro rata and subsidiary. So class, nalaman natin even before pa, no? Na pag yung partnership nalugi, there is unlimited liability for the partners. Let's say malaki yung utang ng partnership. Tapos naubos na, hindi makapagbayad yung partnership. Tapos naubos na rin yung assets ng partnership. Ibig sabihin ba nun, wala na pwede habulin yung creditors ng partnership? The answer is no. Pwede pa rin nila habulin. Pwede nila habulin ang mga partners ng partnership, including the industrial partners class. Right? Including the industrial partners, pwede na habulin yan. Class, take note, no? Nalaman nyo before na exempted sa losses ang industrial partner if there is no agreement. They are entitled to the share in profits. All right? Lagi silang entitled sa share ng profits ang industrial partner. Pero kapag silent, they shall not share in the partnership losses. Okay? But in this case, class, no, meron ng third persons na involved. Meron ng third parties involved. Meron ng creditors involved. Pag kulang pa rin yung partnership assets, yung mga creditors na yon, pwede na habulin yung mga partners. Sa industrial partners included, no? Yung liability nila class is pro rata and subsidiary. Pag-usapan natin yung pro rata. Pag sinabi pro rata, paano ba yan? Does it depend on the capital contribution? The answer is no. All right? It depends kung ilan sila. No? Kasi sabi dito, subsidiary. Bakit subsidiary? Kasi pag magbabayad lang yung mga partners class with their separate properties kapag ubos na yung partnership assets. Yun lang. Pero kapag may partnership assets pa, edi partnership assets muna yung ubusin. Individual liability. A partner may still assume a separate undertaking in his name with a third party to perform a partnership contract or make himself solidarily liable on a partnership contract. So, pwede ito gawin ng partner kapag gusto niya. No? Pero kapag wala namang ganyan, edi yung number one yung masusunod. Alright? So, the partners will be liable pro rata. So, what is pro rata class? Pro rata class is equally or jointly and based on the number of partners, not the amount of contributions. Pero teka muna, saan ba nag-apply yung contributions? Plus yung contributions nag-a-apply ito kapag sa sharing of profits and losses, assuming there is no agreement as to sharing of profits and losses. Doon siya nagmamatter. Alright? Number 2, subsidiary or secondary. The partners become personally liable only after all the partnership assets have been exhausted, unless a particular partner agrees to make himself solidarily liable on a partnership contract. Number 3, liability of industrial partner. So the industrial partner class must still pay third persons, but he can recover the amount from the capitalist partners unless there is an agreement to the contrary. An industrial partner is not exempted from liability to third persons for the debts of the partnership to third persons. So class, let's focus on number 3. So gaya na sabi natin kanina, when it comes to third persons o kaya creditors, no? When it comes to third persons na walang o kaya creditors, tapos may claim pa rin sila sa partnership, tapos ubos na yung assets ng partnership, tapos may claim pa rin sila, pwede na habulin yung mga partners, including the industrial partners with their separate properties. Pero class, ang industrial partner, let's say nagbayad siya, no? Yung sa kakulangan. Kasi nasabi ng batas class, yung industrial partner na yun, pwede niyang bawiin sa mga capitalist partners. Alright? Unless may agreement sila na walang bawian na gano'n. Pero if there is no agreement to the contrary, yung industrial partner, pwede niyang habulin yon sa mga capitalist partners. Pero class, labas doon yung creditors. Walang pakialam yung creditors dyan. Alright? As far as the creditors are concerned, laging pwede nila habulin yung industrial partner. Okay? So liability for contractual obligations of the partnership. So class, take note, no? This talks about contractual obligations. Partnership liability, the partners, including industrial partners, shall be liable pro rata with all their separate property after all the partnership assets have been exhausted for the contracts entered into in the name and account of the partnership. The liabilities are pro rata and subsidiary. Individual liability, a partner may still assume a separate undertaking in his name with a third party to perform a partnership contract or make himself solidarily liable on a partnership contract. So kapag may gagawa ng ganito class, kapag may partner na aako ng responsibility, pwede naman yun, no? Alright? Pero kapag meron, pero paano kapag walang ganyan? So the one who will be liable is the partnership. So stipulation against liability. Stipulation among the partners against the pro rata and subsidiary liability is valid only among themselves, but void as to third persons. So klase, anong sabihin nito, no? Paano pag yung mga partners nag-usap-usap sila? Kahit may kasulatan, sabi nila, for example, partners ABC. Ang usapan nila, pag nalugit tayo, pag nalugit ang pag nalugi tayo kapag may bayad pa tayong utang, no? Ang magbabayad lang ng utang si A lang. Ngayon class, dumating na yung mga creditors ng partnership, naniningil na. Alright? Ngayon, hindi na mahagirap class si A, no? Hindi na mahagirap si A. Ang nahagirap lang nila either si B o kaya si C. Pwede ba nila pagbayarin si B at saka si C? The answer is yes, pwede. Alright? Pwede bang sabihin ni B at saka ni C na, teka, may usapan kami na si A lang magbabayad? Hindi pwede yun as far as the third persons are concerned. No? They can always go after all the partners. Alright? Kung may usapan man si A, B at saka si C, sa kanila lang yun. Anong sabihin nun? Kung nagbayad si B at saka si C dun sa creditors, pwede na bawiin yung binayad nila kay A. But that is their responsibility. Okay? Ibig sabihin, pwede pa rin habulin ng mga creditors at saka ng third persons yung mga partners. Let's talk about power of partner as agent of the partnership. In the absence of an agreement to the contrary, all partners have equal rights in the management and conduct of the partnership business. Each partner is regarded as both a principal and an agent. As to third persons, the relation of partners to third persons is founded on the doctrine of mutual agency. Limitations upon the authority of any one of the partners are not binding upon innocent third persons. The third persons have the right to assume that every general partner has powers to bind the partnership and carrying on the partnership's transactions. Third persons have no duty to make inquiries as to the acting partner's authority. So klase, anong sabihin nito? For example, ikaw, nakipag-usap ka sa isang partner. Alright? For example, ang business ng partnership is hardware business. Tapos kinakausap mo yung isang partner, bibili ka kamo ng, kunwari, ng hollow blocks. No? At a certain price, no? So yung price na napag-usapan niyo na ng partner na yon. Tapos yung pala, yung ibang mga partners, hindi sila papayag sa price na yon. Pwede ba sabihin ng ibang partners na, teka, hindi valid yung sale niyo kasi hindi pa kami kinakausap ng partner na yan. Medyo mahina yung ulo ng partner na yan. Dapat kinausap muna kami. Is there a valid sale class? Yes, there is a valid sale. Alright? Kasi kahit sino ang kausapin, o kahit sino ang kausapin mo dun sa mga partners, it is presumed na yung partner na yun is acting as both principal and agent of the partnership. So your transaction will actually bind the partnership. Hindi kailangan na intayin mo na mag-usap-usap muna sila at magkaisa. Alright? Kahit sino sa kanila kausapin mo, you are already dealing with a partnership. So liability of partnership for acts of the partners. For one, acts for apparently carrying on the usual way of the partnership's business. It is binding on the partnership even if the partner has no actual authority, unless the third person has knowledge of such lack of authority. So class, kapag usual way ng business ng partnership, for example, hardware store, no? Let's say nagbebenta sa iyo yung isang partner, yan mga gamit, no? So it is presumed na may basbas yun ng partnership. Alright? Kasi paano kapag yung partner na yun is wala pala siyang authority na magbenta? Excuse me, class, no? Paano kapag wala palang authority yun na magbenta? Alright? Eh, ikaw naman as a third person, you do not know that. Wala kang pakialam doon. Alright? Iba klase ang usapan kapag ito sa number 2, acts of strict dominion or ownership. No? The partnership is not bound unless authorized by all the other partners or unless they have abandoned the business. For example, class, a hardware store, no? Balik tayo sa hardware store. Ang binibenta pala ng partner sa'yo ay yung store mismo. Okay? Is that in the usual way of business? That is not in the usual way of business. That is an act of strict dominion. Alright? Kasi ang binibenta yung store na mismo. Ibang usapan yun. Pag ganun class, the partnership is not bound. Alright? Unless there is authority by all the other partners. So yung number 1 class, ito yung mga acts of administration. Ito yung kapag nasa usual way of the partnership's business, yan, valid yan. Kahit isang partner lang kausapin mo. Pero sa acts of strict dominion, hindi pwedeng isang partner lang ang kausapin mo, dapat lahat. Liability of partner acting without authority. The partner is personally liable on such contract. Alright? So class, balikan natin yung act of strict dominion kanina na example. Yung sa hardware store, ang binibenta yung hardware store. It does not bind the partnership. Okay? But pwede maging liable yung partner mismo na nagbebenta, no? Kung meron damage dun sa third person na katransact niya. Let's talk about conveyance of real property belonging to a partnership. Number 1. What if the title is in the partnership name, and the conveyance is in the partnership name? Sabihin, yung titulo ng lupa nasa pangalan ng partnership, tapos na nagbenta yung partnership mismo. Yun yung nasa deed of sale, no? Yun yung conveyance. So you're getting the picture, class, no? Nasa titulo, yung pangalan ng partnership. Ang nakapirma sa deed of sale, yung partnership din. So in that case, conveyance will pass title to the buyer. But the partnership can recover the property if the conveyance was not in the usual way of business of the partnership, or if the buyer had knowledge of the fact that the partner who sold the property had no authority. Alright, class? Kasi paano pag ang nakapirma nga is yung partnership pero nakapirma isang partner lang? No? In that case, class, no? Pwedeng bawiin niya ng partnership if it's not in the usual way of business of the partnership. For example, hardware store ka. Tapos yung isang partner pala binebenta yung lupa sa nakatayo yung hardware store mo. Pwede mabawi ng partnership 'yon, class. Assuming na walang authority yung partner na nagbenta. Okay, class? Pero paano, class, kapag yung business naman is real estate development or real estate sales? For example, Avida, Kalayan, Ayala, etc. Paano kapag nagbebenta is isa doon sa mga partners? Is there a valid sale? Yes, there is a valid sale. At saka hindi na pwede bawiin yun because that's in the usual way of business. Alright? Number 2, the title is in the partnership name. The conveyance is in the partner's name. Sabihin, yung title nasa pangalan ng partnership, pero yung deed of sale ang nakapirma yung partner lang. No? The buyer does not become the owner of the land. He only gets the equitable interest of the partnership over the property, assuming that the sale of the land is in the usual course of business of the partnership. Alright, class? So kapag let's say real estate development, no? Ang nagbenta lang is yung pangalan lang ng partner, no, acting by himself, not acting in behalf of the partnership. Alright? So yung titulo hindi pwede malipat dun sa pangalan ng buyer, class, no? Sabihin yan, mapupunta na sa kanya equitable interest. Alright? Sabihin kung ano yung merong right yung partner na yon, yun lang yung mapapasa dun sa bumili. but hindi mapapasa yung title sa kanya. So if you're buying properties class, no, you have to be careful, actually. Especially when you're buying from a corporation or a partnership, ganyan, no? Or even when buying from an individual. Maraming manloloko class, no? It pays well kapag bago ka bumili ng property, magkonsulta ka muna sa abogado or kung sino marunong sa properties kasi ang daming naloloko class, no? Nagbabayad sila ng malaki, like even in millions, no? Tapos yung pala yung pinagbilhan nila yung pala wala sa kanya yung title. No, nasa pangalan pa ng ibang tao. Maraming naloloko sa lupa class. So you have to be vigilant, no? Number 3, title and name of one or more of the partners, and the conveyance is in the name of the partner or partners in whose name the title stands. Madalito, the conveyance will pass title to the buyer. Number 4, title in the name of one or more of the or all of the partners or a third person in trust for the partnership. The conveyance is executed in the partnership's name or in the name of the partner. The buyer does not become the owner of the land. He only gets the equitable interest therein. O parang yung nasa number 2. No? Number 5, title is in the name of all the partners. Conveyance is in the name of all the partners. So conveyance will pass title to the buyer. Sabihin nitong title is in the name of all the partners. Lahat ng mga partners nakalista dun sa title. Tapos silang lahat nakapirma dun sa deed of sale. O pwede yun. Pwede. Conveyance will pass title to the buyer. Conveyance by all the partners passes all their rights in such property. So let's talk about admission or representation made by a person claiming to be a partner. There is a need to prove existence of the partnership using evidence other than the admission itself. Right? Admissions or declarations made in the presence of a person to be charged as a partner are admissible to prove the existence of the partnership. This can happen when the person to be charged as a partner stays silent in spite of his knowledge and hearing distance from the statement made by the person making the representation. So class, pag-usapan naman natin, no? Pag-usapan natin yung mga tao na nagpapanggap na kunwari partner sila ng partnership. Bakit na nagagawin yung class? Bakit sila magpapanggap? To obtain credit, no? Pwede na sabihin na ipautang ng ganito. Partner ako sa ganyan-ganyan. Partner ako sa business na yan. Tapos ngayon class, ikaw naman, dahil let's say medyo nagtiwala ka, no? Naniwala ka dun sa taong yan, akala mo partnership talaga. Akala mo partnership talaga siya nung, let's say partnership ABC. Ngayon pinuntahan mo si partnership ABC, sinisingil mo. Alright? Paano class pag hindi naman talaga partner let's say ang partner is si D, no? Ang sinasabi ni D, partner siya sa partnership ABC. And umutang siya. Umutang siya sa creditor, no? Sabi niya sa creditor, ay partner ako sa ABC. Kasi umutang ako. And naniwala yung creditor, no? Pwede ba si creditor na lumapit sa partnership ABC tapos singilin niya si ABC? The answer is no, class. Hindi pwede yun. Alright? Kasi hindi naman talaga partner si D. Okay? Tapos kumbaga, hindi naman alam ng partnership ABC, hindi naman nila alam yung transaction na yun. So wala silang kinalaman doon. No? O for example, may lumapit sa iyo, oy bayaran mo utang mo kung wala ka naman talaga utang. No? Hindi ka magbabayad, syempre. Pero ngayon naman class, no? Di sinabi ni D na partner siya ni ABC. Okay? Tapos class, no? Paano kasi, for example, pag si A, no? Pag si A, kasama pala ni D. Okay? Ang sabi ni D, ito si A, kakbay ko. Partner niya ako. So mag-partners kami sa partnership ABC. Tapos si A, walang sinasabi, walang ginagawa. No? Ngayon class, pwede ba habulin ng creditor yung partnership? The answer is not the part. Hindi pwedeng habulin yung partnership. Ang pwede habulin ng partnership, si A. No? Because A is a stop class. Importante yung word na estoppel. I-discuss natin later pa. No? A is stopped because by his own silence or by his acts, he is precluded from denying na hindi siya partner. Alright? Kasi pinaniwala niya yung creditor na partner siya ni D. Dahil dun sa ginawa niya, he is a partner by estoppel. And there is created a partnership by estoppel as between them. Okay? As between A at saka si D. Pero si B at saka si C, walang pakialam yan. Hindi sila magbabayad. Ang magbabayad lang si A lang. Alright? Ano dapat ginawa ni A doon? Dapat sinabi niya, o teka, hindi naman niya ako partner. Parang ano, parang loko-loko to, hindi niya ako partner. I have nothing to do with this person. Dapat sinabi niya yun. Alright? It becomes a matter of evidence class, no? Kasi ang dapat gawin ng creditor class, ang dapat gawin ng creditor, dapat patunayan yung existence ng partnership other than dun sa sinabi, other than dun sa sinabi ng ano ni D, no? Other than sinabi ng tao. Paano niya mababawi class kapag ano, kapag paano niya mababawi yung pera? Kasi kapag si D nagtatago na, no? Assuming na walang alam si ABC dun sa transaction. Anong magagawa ni ano ngayon? Anong magagawa ni nung creditor ngayon na nagtatago na si D? Tapos hindi pa niya alam yung address ni D. Hindi na makasuhan. Hindi wala siyang magagawa class. So you have to be careful. You have to be vigilant when extending credit, no? Admissions or declarations made in the presence of a person to be charged as a partner are admissible. So gaya ng sinabi natin kanina, no? So let's say tahimik ka tapos sinasabi nung tao, "Uy, partner ko 'to. Okay, may partnership kami." So ngayon pabili niyan, pautang nito, pautang niyan. O class, kapag pinapamukha mo na partner ka nga, o kaya kahit tahimik ka lang, kahit wala kang sinasabi, you will become liable class. Right? You will become liable as a partner by estoppel. So notice to or knowledge of a partner or of matter affecting partnership affairs. Notice to or knowledge of any partner of any matter relating to partnership affairs operates as a notice to or knowledge of the partnership except in case of fraud. A third person need not communicate with all the partners. If notice is delivered to a partner, that is already effective communication to the partnership. Right? So class, pag sinabi mo sa isang partner, ay bibili ako ng ganito. Tapos, ayan, itong bayad ko. Binayaran mo na yung tao. So class, ibig sabihin pag ganun, the moment that you transacted with a partner, alright, hindi mo na kailangang intayin pa na sabihin niya sa ibang niyang partners. You are already transacting with the partnership. The partnership is already bound. Okay? Hindi mo kailangang intayin, no? Na mag-usap pa yung mga partners. Una, ito yung mga transactions natin, ganyan. Hindi. The moment that you are talking to a partner of a partnership, you are already talking to the partnership. Liability arising from partners' wrongful acts or omissions or breach of trust. So class, this is interesting. No? There is solidary liability. Class, take note, solidary liability. So by now, dapat alam niyo kung ano yung joint liability at saka solidary liability. No? You have learned that in your obligor. So there is solidary liability among the partners for the partners' wrongful acts, omissions, or breach of trust acting within the scope of the firm's business or with the authority of the co-partners. Whether innocent or guilty, all the partners are solidarily liable with the partnership. The act or omission is called quasi-delict or tort, which you learned in your obligor. For example, class, no, a delivery truck driven by a partner for partnership business purposes hits and damages another vehicle. So yung truck na minamaneho ng partner nakabangga, no? Pero yung pagmaneho ng truck for partnership purposes. Well, let's say hardware, di ba? Let's say yung hardware niyo may truck. Tapos nagde-deliver kayo ng supplies. Tapos yung nag-drive, partner siya ng partnership. Right? Nakabangga siya. Kapag ganun class, the partners are solidarily liable. Alright? Pero class, di ba kanina merong joint liability sa mga partners, di ba? Tandaan niyo? Yung kanina, class, no, yung joint liability, it only applies to contractual obligations. Contract. Alright? Dito, sa solidary liability, there is no contract. There is quasi-delict here or tort. No? Isa pa example class, hardware store, no? Let's say yung partner na kinukuha ang gamit sa shelves, no? Tapos accidentally hindi sinasadya, no? accidentally, natapik niya yung, let's say yung lata ng pintura. Nahulog yung lata ng pintura, nabagsakan yung customer. No? Pag ganyan, the partners are liable solidarily. Okay? Is that clear, class? Siyempre, kung sino yung nagbayad, pwede na singilin yung guilty partner. Pero that's among themselves. But as far as third persons are concerned, there is solidary liability among the partners for a partner's wrongful act, omission, or breach of trust. So what about misapplication of money or property of a third person? If a partner receives money or property of a third person within the scope of his authority, and the partner misappropriates the same, the partnership is liable. Alright? O maganda example nito, class, no? Pawn shop. For example, merong pawn shop na partnership business. No? So yung isang partner, no, kinuha, parang let's say merong tao na nagsangla ng alahas. No? So kinuha ng partner yung alahas. Tapos nagbigay siya ng pera. Ang ginawa ng partner niya, class, tinakas niya yung alahas. Alright? Tapos nagtago na siya. Ngayon, magiging liable ba yung partnership doon? The answer is yes, magiging liable yung partnership. Alright? Hindi pwedeng sabihin ng partnership, teka, wala kaming kasalanan dyan. Ang may kasalanan dyan, yung partner namin na tumakas na rin. The partnership will still be liable. Because that's in the usual way of, yung ginawa yung pagtanggap ng property ng partner, that's within the scope of his authority. Okay? So class, what is partner by estoppel? Partnership by estoppel. So let's discuss first the meaning of estoppel. No? Estoppel is a bar which precludes a person from denying or asserting anything contrary to that which has been established as the truth by his own deed or representation, either expressed or implied. So balik tayo sa example kanina. No? Pero isang tao na sinasabi na partner niya si A. Okay? Tapos si A, walang sinasabi. Parang tahimik lang siya. Is there estoppel, class? Yes, there is estoppel. There is estoppel. Kapag may kaharap na third persons, class, no? Tapos yung third persons naniniwala kasi hindi nagsasalita si A, there is estoppel in that regard. Okay? Kasi nangyayari doon, naniwala yung third person na partner nga si A kasi wala siyang ginagawa. Lalo na, class, kapag sinabi nga ni A na, oh, partner ako, kahit hindi naman talaga. There is still estoppel there. When a person is a partner by estoppel, and a person who is not really a partner may become a partner by estoppel and thus liable to third persons as if he were a partner when he directly or indirectly represents himself as a partner in an existing or non-existing partnership. All right? Partnership by estoppel, if all the actual partners consented to the representation of a person who claims to be a partner, the partnership is liable. So class, ibahin niyo yung partner by estoppel at saka partnership by estoppel. Yung partner by estoppel, edi yung isang tao lang, no? Na sinasabi niya na kunwari partner siya. He is liable as a partner. Pero magkaroon na buong partnership mismo? Can there be a partnership by estoppel? The answer is yes. Alright? Kasi lahat ng partners sinabi nila na partner nga nila itong taong to, and the whole partnership is liable. Alright? Ang purpose, class ng estoppel, no, this is to protect third persons who are transacting with the partnership or the persons who are claiming to be partners. Alright? Kasi class, hindi pwedeng sabihin ng mga tao na manloloko na, bakit naniniwala na partners kami? Nagbibiro lang kami. Oh. Okay, kaya hindi kami liable sa iyo. Hindi pwede yung class, no? Kasi nanloko ka no? So you have to be liable. That's why merong estoppel. It can be mere silence, it can be the actual words spoken by the person, it can be actions. So yan ang estoppel class. No? So when liability is pro rata, when not all of the partners consented to the representation, all those who made and consented to the representation are liable pro rata and are jointly liable. So ang sabihin dito, hindi lahat ng partners pumayag na consent dun sa representation. Ibig sabihin, yung partners lang na consent dun sa representation, sila lang yung magiging liable along with the person who represented himself to be a partner in the partnership. So when is the liability separate? When none of the partners in an existing partnership consented to the representation. Balik tayo sa example ng partnership ABC. Para pag hindi naman talaga alam ng partnership ABC, na for example, meron lang tao na sinasabi niya na, oy, partner ako sa ABC, pautangin mo ko. Hindi pwedeng singilin ng creditor yung partnership ABC. Kasi hindi naman talaga niya alam eh. Alright? Ibang usapan class. Na pag yung creditor, pumunta siya sa office ni partnership ABC, tapos tinanong niya kung si D nga ay partner. Para pag si ABC, para kapag yung ABC partnership, sinabi nila na, oo, partner namin yan. O paano kapag yung partnership ABC, wala silang sinasabi. Silent lang sila, nakatingin lang sila doon sa tao. Estoppel na rin yung class. Alright? Estoppel na rin yun. The partnership will be liable in that case. Estoppel does not create a partnership. There is no partnership among the alleged partners. There is no contract among them to create a partnership. No? As far as partnership by estoppel is concerned, no? It's only with regard to the protection of third persons. Pero wala talagang partnership. It's as if meron ng partnership para mabayaran yung mga third persons that are prejudiced. So, preference of partnership creditors and partnership property. With respect to partnership assets, the partnership creditors are entitled to priority of payment instead of partners and their separate creditors. So class, pag may assets yung partnership, tapos may utang yung partnership mismo, yung mga creditors ng partnership, sila yung uunahin. No? Sila yung uunahin para sa pagbayad ng partnership assets. Alright? Pag nabayaran niyo yung partnership creditors, okay class, pag nabayaran niyo yung partnership creditors, saka naman i-distribute yung matitira sa mga partners. Tapos doon na lang babayaran yung mga separate creditors ng mga partners. So class, again, nauunahin muna yung creditors ng partnership mismo. Tapos kapag ubos na yung partnership, kapag nabayaran na lahat ng partnership creditors, tapos assuming na mayroong matitira, yung matitirang yon, i-distribute na sa mga partners. Alright? Tapos yung makukuha ng partner, yun yung ipababayad naman sa separate creditors ng mga partners. So, so hiwala yung partnership creditors, hiwala yung creditors ng mga partners. So class, we end here. And next, we'll talk about corporation law. So take care, class, and good day. Stay safe.